Hey, good afternoon. It's Bill Gross, the LA Probate expert, and this is our Thursday, probateweekly.com. We get together every Thursday, 4 p.m. Pacific, 7 p.m. Eastern, and all the times in between and on either side, to talk about all things probate real estate. I'm a probate real estate focused real estate agent in Los Angeles, California, and I have a national team of experts. We just opened this last month. Oh, there's our guest. We just opened in Florida. We've been in Georgia. We're in 9 counties in California and adding more all the time. And so we interview attorneys from around the country, vendors from around the country to try to help us. And I think on one hand, it's great to learn about specifics in other venues. It's also, I think there's certain, what I've learned interviewing now attorneys in about, I think 10 states so far, that there's certain common principles in all of them related to the business, how attorneys and realtors work together or don't work together effectively, and how we should work better. And so I'm really excited to have today, I see, I just unmuted him, I think, Rob. Or actually,
Hi.
unmuted. Hey, how you doing?
Good. How are you?
Good. So, I look for, I've been getting as a real estate agent and running this particular program regularly, I get requests regularly for Las Vegas attorneys because people move from California to Las Vegas. Maybe they still own property here, or they own property there, or their parents own property in one or the other. And I started reaching out to friends and family for attorneys in Las Vegas. And it turns out that one of, I would say, close friends before they left us, but moved from Los Angeles to Las Vegas. And his wife and Rob Tzall have been friends of ours for a while, moved to Las Vegas. He's been a practicing attorney in family law and probate and estate law for a while. So I invited him to join us today. Rob, say hi.
Hi, everybody. Great to be here.
So just a little quick background. Where did you grow up? Where are you from originally? And how did you get into law school and become an attorney?
So I'm still not sure how I got into law school exactly, but I did get into law school. No, I'm just joking. So I grew up in Southern California, San Fernando Valley. You grad at UCLA, law school.
Whoa. Where?
I was told we weren't going to have. I was told we were just going to put that out
Okay,
there.
I'll let it go. Okay, I'll let it go. I'm not judgmental. I'm not judgmental. Go ahead.
And I went to law school at the University of Miami, where I graduated in 2006. And since 2014, I've been admitted attorney since 2007. And in 2014, I started entering into my area of family law, which is estate reproduction. And as a result, I saw that when people are building families, with any of the different ways they do it, they start having questions about their legacy, whether it be money legacy, whether it be their wishes, etc. And so in 2006, I branched out into estate planning, and I've been helping clients in Nevada, Utah, New York, and Jersey since then with their estate planning needs.
Fantastic. So again, in the states of Nevada and where else?
Nevada, Utah, New York, and New Jersey.
Utah, because Utah kind of borders, the southern part of Utah borders on Nevada, and then New York and New Jersey because you're from there, or because it's common that people have estates in Las Vegas and New Jersey, New York? What's the connection?
So before we moved here to Nevada, I kind of gave you the condensed version. We lived for 6 years back east in New Jersey. And so it was very fun to be in New York, New Jersey. But opportunity brought me here to Nevada, and we've been here since 2013, and I've been very happy ever since.
Very nice. Very nice. And just a quick shout out to his wife, who runs a business very successfully all over social media. And how many kids do you have?
5.
5 kids. Wow. We knew Heather, his wife, and before she was married. Next thing you know, she's married. We met Rob, and then the 5 kids. So you guys have been real busy here while you're practicing your law. So you're more, I think, in the estate planning or the avoiding the problems by prevention and planning than you are on the probate litigation side. Is that a fair assessment?
Correct. My practice ethos is the best type of attorney is one that keeps you out of court. Me personally, I don't like court. I think it's much better when people have control over what they want to do. It's better for everybody. It's not only faster, but it's certainly cheaper.
And I want to say, because I get from real estate agents sometimes, well, then why is he on the call if he's preventing probate? Doesn't need us, and it becomes a trust sale. We all know how to do that. Why do you have him here? The answer is, I believe you should make relationships with estate planning attorneys like Rob in your marketplace. Make sure your clients have relationships with attorneys like Rob and get good estate plans in place to avoid probate. And if we all did that and probate was eliminated, as if it's possible, we would all not only have happier customers, but we'd make more money in the long run. I think everything would work out better for everybody. So I'm aware that this isn't about how to not do business, but it's about how to do business by establishing relations with attorneys like Rob in your local marketplace. So Rob, how do people come to you typically for an estate plan? Is it something that people on their own come to you and it's a referral, or do you market to it, or how do people come to you?
So my practice is referral, and it's really people that two other sides of my practice are, like you said, the family law as well as transactional work. So a lot of clients, I have relationships with those from those practice areas, tie in nicely when they start thinking about as they get older or the next steps in their lives with estate planning. Additionally, the relationships that I've made with my referral sources lend themselves to people not only from a financial point of view, but from just a way of life point of view, that they are planners. And so, those are the types of people that I like to work with. So I've kind of geared my practice to be able to serve those people, because I think when you have that linkage, I think it works out best for both parties.
Is it true? It is true in California almost always that even a bad estate plan is probably as good, if not better, than no estate plan at all, meaning as the alternative being probate. Is that true in Nevada as well?
I would agree with that, with one caveat. And I see this typically, you mentioned, because you were actually right. A lot of my clients are former California residents who now are here in Nevada. A lot of them have done some sort of planning in California, and they'll call me and they'll say, we need to change it to a Nevada trust. Well, there's no need, but folks should know that when they're moving, for example, their trust has provisions in it governing what law or where things have to be litigated. So one thing is, if you're moving to, and if your intention is to have to, for the trust to be governed by the law of the state you're moving to, or to be litigated in that state, to kind of do a tune-up, a check-in with somebody in that new place where you live in. But other than that, I agree with you saying 100%.
And so just to recap, most commonly attorneys in California, or even national attorneys who do plans for Californians, would normally write litigation according to California law. And generally, in the default for you, if somebody lives in Nevada, you would put it under Nevada law. And so if you move, you should make sure that you have it for the right location based on where you want that to be.
Exactly.
Yeah. One of the most common challenges I see is that people take the time to get a estate plan done and then don't move the assets into the estate. In California, there's a process called the Heggstead Petition, where oftentimes the family will say, hey, dad and mom created this trust. They maybe had the property deed in the trust at one time. They took it out to refinance and they didn't put it back in. And there's this famous case called Heggstead where the court allowed the intention of the decedent to override the legal paperwork. And it's a fairly commonly accepted procedure in California. Is there an equivalent in Nevada, or are you out of luck if the property is not put into the trust?
You're out of luck. If it wasn't, the presumption is, unless there's some evidence of an error, the presumption is that it wasn't put in the trust. And like I said, unless there's something extraordinary, it cannot be put in the trust.
Okay, so unlike California, where we kind of have a do-over opportunity, but it can be expensive and it still can take time. In California currently, we're in LA County, for example, a Heggstead petition, which is simpler than probate, and I say it in quote marks because it's not, just the first hearing is 6 months. So because the court's so backlogged, so it's not quite such a simple process. One of the other common problems I see with clients who do trusts is that they meet with the attorney, they write the world's greatest plan, they maybe fund the trust completely perfectly, and they go home and put the trust who knows where, and the mom and dad pass and nobody can find the trust. Is that a common problem? And in Nevada, what's the law when the property, let's say, is deeded in the trust, but nobody can find a copy of it anywhere?
So if there is a trustee and there is a certificate, either there's physical evidence of a certificate of trust, or a party can come forth with evidence that they have in the trustee, even without the supporting documents, you can get an order. You can get an order declaring that the trust does exist. You'll hear some attorneys say it's not good to have multiple copies of the trust. I would disagree. I think one copy should be obviously with the trustee, one should be with the successor trustee, one should be with a relative, and then one should be with your financial planner. And then it's belt and suspenders. And then you can have a digital copy as well. So it's really belt and suspenders. But it's costly. It's costly, but it is possible. But I would certainly recommend folks, like I said, put multiple copies with multiple trusted advisors. So that's.
And when you say multiple copies, I assume you mean multiple originals with original signed documents, or will Xerox
No, I
copies
would
doesn't
say
work?
no. One original would be executed, and then the rest would be certified as accurate copies.
Got it. Certified copy is available to
Yeah.
the parties. What if there's evidence of a trust, meaning property is deeded in the trust, we know it was done at one point, but there's no evidence, no successor trustee shows up with a copy, they didn't take the proper plans, it is as though it doesn't exist physically in the world. What's the law in Nevada regarding that, and how is it different in other states?
So every state is different. And if I can get the scenario correct, you're saying that there was the person during the grantor during their lifetime was the trustee, and then they passed away and no successor trustee came forward. Then an interested party like a beneficiary could petition the court, and the court would appoint a trustee, or another interested party. Let's say there was a creditor to the trust, they could do that as well. But there'd have to be some sort of interested party enough to say, hey, this trust does exist. It is legal. It's not legally defect. It's not legally defected. It should go forward, but there is no guidance about who the trustee should be. That said, I think good practice is always to not only name a successor trustee, but a second successor trustee, and then specifically have a clause in there that even if they fail, beneficiaries have the right to petition the court to declare that somebody should be the trustee.
And then absent specific instructions, meaning there's no trust document, would the normal succession apply? Would the court just go to the default process as far as distributing the assets?
You mean if the court finds that there is no trust, or if the court found that there was no trust, or there was no evidence that there was a trust, and there was no and the pour-over will wasn't what didn't have any clause in it to say what happens if the trust should fail, then it would follow your laws of intestate inheritance.
Yeah. Interesting. Look, guys, I'm going for hours of stuff. This is fantastic. Get a chance to talk to somebody who's real life attorney. And I'll give you the disclaimer. He's not giving you legal advice. He's talking generally about the procedures and practice as we deal with as real estate agents and investors in the state. And he's not even in your local state, probably, if you're listening from California or other states. So again, don't take it as legal advice, but I would say take it as ideas on how to solve problems or good questions to ask an attorney that you're working with in your marketplace. That's really my goal of this. Maria, I see your hand up. Besides a shout out to a fellow San Fernando Valley resident, do you have a question for Rob?
Yes. My question is, if you reside in California but own a property, say in Nevada, should you have two trusts, or can you?
No, unless there's some sort of need for it unique to those folks, to have one trust and having it own property in multiple states is not a problem.
Okay, so a trust from California would be sufficient for Nevada owning a property. Okay.
Yeah, again, as you said in the beginning, it might be one to change it because the laws that'll be litigated would move, but there's no necessarily a reason why you would have to, based on what you're saying. So good, thanks. Eddie asks, how long does a probate transaction take in comparison to a regular transaction? So, in California, theoretically, to sell a property that needs a probate with full authority, theoretically, you file 30 days, get approved, theoretically sell the house, normal escrow period, maybe add 15 days, and the house is sold, but the money stays in the probate till it's completed. What's it like in Nevada and the other states you've experienced in, Rob, as far as selling a property where there's a probate involved? How long does it take extra to get a property sold?
It's a big range depending on what that estate looks like. But I'd say on the short end, it would be 4 months. Soup to nuts with escrow closing. But folks just came to me and they were waiting a year till they got the authority of the court to ultimately sell the property. So that was a unique case. So I'd say usually 4 to 6 months is the average time that we have here in Nevada.
I could tell you in LA, it's not uncommon. There's no reason that it should take that long, but the average sale time for a property in probate from the sale date if you back up to the file date, is about 1 year and 3 months on average. Now I have them all the time, 2 and 3 years because of litigation, objections, problems getting appointed and things like that. So yeah, definitely a different issue. King's Estate, I don't know if that's your name, but your hand's up and I'll ask you to mute and go ahead.
Hi, it's Philip King with King's Estate Services in Charlotte.
Oh, that's right.
It's almost like a two-part question. I understand what you're saying about with the court. Let's say the trust is being administered in the state of wherever, and there is a property in the state of North Carolina. Can that probate process or whatever process they're using in another state handle the property transfer in North Carolina, or does it still have to be filed with the local clerk through the probate office in order to be able to sell the property? Number one. Number two.
Let's start there because that's a complicated. I can imagine there's some complicated answers to that one. Let's start with that one. Hold on a second one.
Yeah. So once there is an order from this court, let's say it's Nevada, and they're having to go to your case, North Carolina, that would have to be what's called domesticated in the local courts in North Carolina. So then you would have to at least engage at a minimum a civil attorney in that other state in order to get that domesticated. And then if you really wanted to go for it, you would work with an estate planning attorney just to do that matter in that state.
And those rules are going to vary, I imagine, from state to state and how they handle reciprocation and rights and admission and one-time admissions and things like that. So I think the best answer is it's going to vary based on the particular of those two states. Yeah. Okay, good. And second question?
Is if, let's say I establish a trust here in North Carolina, I have property here in North Carolina, but then I move to Michigan, for example, and pass away, but my trustee is in Michigan. Can they administer it from the state of Michigan, or does it have to start at the point it was originated for the trust?
So typically there's no issue with somebody out of state. And if someone being a resident of the state where the trust wasn't created in, or a different state, there might be restrictions in the trust document itself, but typically that's not going to be an issue from a statutory point of view.
But again, I think that may or may not vary based on different states. And
exactly,
you might want, if it's, you have enough time and attention, consult an attorney in the particular state that you're in your case, Michigan and or North Carolina. And I know we have an attorney from North Carolina coming on in May. So stay tuned or watch us on YouTube and you take Rob's question, answer, and run it by them and see how they feel about it. Okay?
Thanks.
Great. Anybody else who has a question, feel free to raise your hand in the Zoom or put it in the chat box, and I'm doing my best to kind of keep up with everything. You're welcome to shout out if you have service, want to promote yourself. Love to get referrals with each other. Love to share business. That's why we do all this. But if you do, put either a Q or a question by it, so make sure I flag that as a question. Robert, another question, do I handle probate administration in Nevada? I think you mean the guest does, Rob. So do you handle probate administration in Nevada?
So I don't do probate myself. It is a process that is very tedious, as everyone here on the call knows, and it's something that I find that my strengths are better served in the actual drafting and working with the parties to get their needs across, and I leave that to other folks now.
Okay. Do you have somebody that you would refer them to if they have a question on probate? I assume when you say, sometimes people say administration can be filing the original probate. It could be actually getting more involved if there's litigation and such. So Christopher, it depends on what you're looking for. But Rob, in general, do you have somebody that you refer to for basic probate filing and basic administration?
Yeah, and I have several folks, and they can reach out, and folks can reach out to me, and I'm happy to pass on that information if they need that.
Great. Okay, good. And so we'll have his contact info in our chat box, and I'll put it up at the end as well. Good question. That's the goal here, is to really create referrals. I'm in different groups. I'm involved with alltheleads.com. I'm involved with Chad Corbett Probate Mastery. In fact, I'm a coach on his program, and I host that sometimes. I have my own group. And I see people ask questions, and then does somebody know an attorney in San Diego? Boom, they give the name of somebody. And I always search the attorney. What I find is we all have friends who practice various things, just like real estate agents. I'm licensed to sell from the Golden Gate Bridge down to mobile homes, but I wouldn't sell mobile home, and I wouldn't sell the Golden Gate Bridge. I have my niche that I do real well. And I think the best attorneys have those niches fairly defined too. So when you find somebody that you want to get a referral for somebody who specializes in that field. And I think Rob's right to point somebody out as well. Chip, you don't need to raise your hand. I got you in the chat box. You have a question? I can unmute you, though. I got to find you here first. Let's see, or you can unmute yourself. There you go.
Okay, so my question is kind of related to Mr. King. Here in the state of Florida, we have what's called ancillary probate, which means that somebody is from another state, but they had property here in Florida as long as they could have, property in New Jersey, New York, and that might be where the residence was, or it would have to be the residences of another state, but they had property here in Florida, but they're a legal resident there. So they petition the court here, what's called ancillary probate. And basically, because it is Florida property, it gets handled through a Florida court. Is trust kind of similar in that if the the trust was created in New Jersey, they would include a property here in Florida in that trust, and it would be handled, I'm sure differently, but kind of similarly?
So if in the trust, the trustee themselves will have the power that they won't have to go to the court to get any permission to do any dealings. We're talking about the successor trustee here. So that wouldn't be an issue with the trust. They similarly, let's say someone was sitting in California and they own property in Florida, they would have no problem selling their property in Florida. They wouldn't have to avail themselves of any further thing other than listing it and ultimately signing the contract and completing the transaction. You mentioned ancillary probate. The states, for example, Nevada doesn't have such proceeding. So, but that's, as Bill was saying a few minutes ago, and I would agree with him. Certain states do have certain statutory or court enforced means that other states don't have. So you do want to speak with an attorney in those states to make sure that you know exactly what you're doing. I find that the best attorneys are never intimidated when you say, "I'd like to speak to another attorney."
Yeah, if they're intimidated by it, that means they're the wrong attorney by definition.
Right. Exactly.
Good
Exactly.
point.
And Bill, something you mentioned in the beginning about developing relationships. What a document that creates a trust really is it's a set of instructions. And in those instructions, we're talking about trustees, but trustees can give successor trustees more limited or broad authority. Like, for example, if a particular person has a relationship with a broker that they like, they can tell their trustee to work with that brokerage to ultimately list the properties when it comes time to do that. So it's not just so probate, which is probably the thing that you see the most. There's also an ability to have relationships with folks that we can build on the trust side as well.
One of my colleagues, Tanya English, she's a professional fiduciary as well as a real estate agent, and she actually has certain clients write in the trust that she's to handle the sale of the property because the person the trust is written for, the beneficiary, wants a relationship with her, trusts her. She maybe brought the attorney or the trust, the estate planner to them, and they want to work with them as a team and offers team services. So definitely there's a strategy there that some people use effectively. Great. And then the other thing I would say about multiple states, this little shortcut, Rob, that I use is if you don't have a plan for your assets and your medical decisions where you're not capable of, the state you live in has a plan, and it looks a lot like getting a driver's license. So here in California, if that doesn't scare you in the estate plan, you haven't been to the DMV in a while. In other states, it's not such a big deal, but in most states, you don't want the DMV to determine who sells your house and how much and how money gets divided. You want to have input on that yourself. So that's just a shortcut to how to look at other different states. King's Estate, again, we have your hand up. I remember you from North Carolina, but I don't remember your first name. I'm sorry. Is it Pat?
Sorry, it's Philip.
Philip King.
Philip, yeah. So most of the clients that I deal with, we're looking at when I'm engaging them, we do full service estate services, estate sale, liquidation of contents, all that stuff. I am also the realtor in a lot of distractions. We also do those services for other realtors. So we're normally looking for the letters of testamentary as our engaging document. That's what we need in order to, that's what my company, I'm with EXP, most of the time they're looking for that document in order to show that that person has the legal authority. So are you saying that if there's a trust there, that instead of the letters of testamentary, we can just substitute the articles of trust that were filed, and then that person, we don't have to worry about a successor as long as the primary trustee is there? Is that? And then what do I do how do I determine if the original trustee versus a substitute trustee is who I'm talking to?
Yeah.
So, Bill, go for it, please.
Well, I was saying California, from an EXP and from a real estate procedural perspective, the California Association of Realtors has created a form for us to use to give to the client to declare their authority, and they're going to make select what their authority is and provide the documents to back it up. So we're relying on them telling us the truth. We're not responsible to investigate, but I will say the first thing then I do is take it to a title rep who either research the last document that was done by them if there's a chain, or if not, then we'll have to do some more research. Rob?
So if I understand correctly, so there either testamentary letters, or in the case of a trust, a certificate of trust is a document that's signed under penalty of perjury, where you're declaring that you have the power, you are the person named the document, and you have the ability to execute the powers in that document. Most places will accept just a certificate of trust. The reason the document creating the trust is important is so the successor trustee knows what their directions are. But like you said, California, they have a form. Other places, they might have a form, or an attorney might just draft it as part of the representation. But that's pretty easy and straightforward.
In California, we used to have a separate form, the RCSD Representative Capacity Signature Disclosure Form, that you have to remember to attach with a checkbox. Now it's actually built into the standard residential purchase agreement form. And so there's room right there that if it's a trust or a estate or it's a LLC, corporation, that right there you'll put the checkbox and what the name is and whether you're providing the documents or not at the time of signing the document. So as a realtor, again, our job is to ask the client to present what their position is, and then at some point all that gets checked out. But it's different in every state, obviously. Good. Chip, I see your hand up again.
Yes, what Mr. King was talking about, I had something very similar. And like Bill was saying, whether you deal with a title company or a real estate attorney to do your closings, that's who you really want to submit the documents to, because then that puts you in the clear. You didn't make a decision based on what you think. So I had one that the daughter wasn't originally in charge of the trust, but the person that didn't want to deal with it. So he signed it over to her, and I looked at it and it looked good, but I'm not an attorney. So I sent it to my title company, and their attorney looked at it and they said, yep, everything's good. She has the right to sell it. You can move forward. So we did, but that's who I would go to, is whoever you use for your closings. There should be an attorney involved, and that's what their job is to keep it out of trouble.
Yeah, and I think sometimes there are things that are legally acceptable but won't get insured. A common example for us is in California when we sell on a probate, even with full authority, the title companies won't insure the case unless there's a 15-day notice of proposed action, which is a filing that tells anybody, the public, we're selling the house, here's how much we're selling it for, here's who we're selling it to. And now if attorneys say, well, that's not required because the petitioner is the only beneficiary, blah, blah, blah. And I said, well, you're right legally, but there's no title company that will insure that. They want the extra protection of the filing on the court case before they'll be comfortable to issue title insurance. And basically, if you can't get title insurance, you really can't sell the property. It doesn't matter how right you are legally. Nobody's going to buy the house. It just doesn't work that way. Okay, I see Nikita has a great question. And I don't know if you're able to unmute yourself, because the key thing is going to matter is what state it is in. I think always the first thing, if you're going to ask a legal question or scenario question, you really need to identify what state it is, because the laws do vary from state to state. But she's the successor trustee of her sister's trust. Your sister passed away, sorry for your loss, and unfortunately had transferred the condo to the trust. Classic. Can I transfer it into her trust now that she's deceased without going to probate? So that's what we talked about in the very beginning. In California, we have a process called a Heggstead Petition, where you would go to the court and say, she had a trust, she did the condo, she intended to put it in the trust, never did that. And if the court's satisfied and there's no objection, they'll allow you to treat it as though it's in the trust and after the fact, and it's kind of like a do-over. Rob answered the question that there's no such process in Nevada, correct?
Correct. So in that case, if there was a pour over will, the pour over will could direct, if the pour over will directed that any property, any residual property in the estate be transferred to the trust, that'd be pretty straightforward from a probate point of view, but it would still have to go through for the property that's not in the trust, there would still have to be a probate opened.
Right. And so the pour over will is a pretty standard piece of an estate plan, right? So almost anybody with a living trust, I would say 95% of the time, there's a pour over will as part of the document package that they end up with. Would you agree
It
with
should
that?
be, but yes, you're entirely right. If you're just because there are other properties that we talked about, people forget, people can't put in for different reasons. And so it's really important to have a pour over will. And also a pour over will is going to be that document, if you have a trust, that if you have children, minor children, you're going to be able to name who you think the guardian should be. You're going to name your wishes about corporeal disposition and things like that. So when I do a revocable trust, it automatically includes a pour over will.
Nikita, I see you unmuted yourself. Nikita Jones, Houston is your last name. Does that mean you're in Texas, or where are you located? Where's the question
No,
located from?
I'm in California. I actually put that I was in California, but I did it
Oh.
in the second statement.
Oh, I'm sorry.
Yes, unfortunately, we did not have that second document. And we actually went to the court to put the property into the trust, but it didn't have the name of the trustee on the document, so they rejected it. And so
Yeah.
she passed in the process. And so now we're left with just that. He was able to get everything else because she had designated him the beneficiary of it. But we just want to transfer the property into his name so that he can have that and do whatever he want to do with it. It still has a mortgage on it, but it's still in her name.
Well, I went to court often enough and saw this happen enough. I can say the court is very particular on the paperwork, on the process for Heggstead, because you can imagine you're trying to say there was a mistake made. But I've seen the court, when the process is filed properly, over and over again, allow properties like this to go back into trust. So, maybe you just need to get the right service. I'd be glad if you want to reach out, Nikita, to make a couple
What did you
suggestions
call
for-
it? A hex?
Heggstead, Heggstad. It was a famous
Heggstead.
court case in
Okay.
California. Yeah.
Okay.
So again, I'm not giving legal advice, but I've seen those
Right, okay.
petitions. I've seen that process. And basically, you go to the court and saying, well, it was meant to be in the trust, but it's not. We acknowledge it wasn't done. I've seen cases where they had the wrong property description, wrong parcel number, and also they just left it out. Maybe they took it out for refinance or they never put it in. I've seen every one of those examples, and I've seen judges accept them. I've also seen they're very particular. They want every piece of paper done right because they're going on the line. And as Rob said, other states don't allow it. It's really, the judge can do whatever the judge wants. I think that's the thing I try to tell people. You can know the law, you can be writing the law, but if the judge says no, it's no. The judge says yes, it's yes. It doesn't really matter to some degree. Matt asked, did she have children? Because that's a whole different question. But I think at the end of the day, if you're trying to act the fact put in the trust, I don't think that matters much. Okay, and
So actually, you mentioned something about children in trust real quick. Something you think the person that if you have minor children or you have children or you have adult children but they have special needs, not the person who you want to be their guardian isn't necessarily the person who you want to be trustee. The person that can give them the most tender loving care might be the absolute worst with finances, and they might actually, instead of being people think of what? Oh, my mom or my dad or my sister, my brother, something like that. But really, people have to think about, these are roles that the parties get to choose, and they really sometimes it's not one person, it's multiple people.
here's a great question. Christopher asks, does Nevada have a procedure to purchase an heir's interest in an estate, In California, it's called an assignment of interest.
You can, short answer is yes. Longer answer is it would be a contract of the parties. You'd be basically selling your inheritance for whatever you have, whatever the value is. But as far as that would, there's no formal procedure that would have to take care of that out. Unlike other than showing the assignment paperwork in the probate process.
Yeah, this is an area that's politically controversial in some states in that there are people who got property back in the post Civil War period, and for example, freed slaves got a certain amount of land, and you can imagine 160 years ago, and in the first generation had more kids than we have now, and the second one had a bunch of kids, and so you might have 3 generations later literally hundreds of heirs to a piece of property. And then there'll be investors who will buy up those interests. Now, CalPERS would say, well, they're getting fair value. But on the other side, they say, well, yeah, but they're also taking advantage of people who are maybe poor and educated and don't really know the value. And so it is an area that's very politically charged, but it also is an area that can be used to help people who need money and want to just sell their interest in an estate and don't want to go through the process of litigating or going through an entire probate process. So there is such a process, but as Rob said, is that something that you would do in Nevada? And is it also something that might be done in New Jersey and New York where you can buy the heirs' interest in an estate? Is that something that you've been involved with? I'm
trying to think of a situation that, there's a situation that I'm involved in, and it's similar to this. And even in that's not the approach we're doing. Like you mentioned, there's, I'll use the word, perhaps you won't go in this so far, but there can be exploitation. And really, if, to get the value out of the assets, it really behooves people to wait to sell them in a normal arm's length transaction, and then divide whatever the proceeds are. Unless somebody was just in a rare situation, I might recommend it, but I couldn't see that would bring the most value to the parties, to the interested parties.
Yeah, I mean, I've had cases where an heir to $300,000, $600,000 worth of real estate. There's another party and they need money to get an attorney. The attorney won't do it on contingency. They have the money to put up front, and so you'll advance them part of their heirs, some of the beneficiary interest, $10,000, $15,000 to advance to pay fees and litigation, maybe some extra walking money to get through that time period. So it is used there, but again, it's something that should be used judiciously and use the word, I think that's the right word, exploitation, because you're not exploiting people when you use that.
And even that, I mean, just from my point of view, it's not perhaps not the right word, but I would even see that really, which you just suggested, is really contingency. And that's something, that's really to pay the legal fees. But if it's really the matter of, someone needs cash quick, like you said, they could do it, but they would get far less. They'd get far less value.
Yeah. And Chuck Simmons was nice enough to put a link to the Heggstead Petition explanation how that works in Los Angeles. Let's see. Donna says, do you have a chapter you are affiliated with that provides the same type of advice in Florida? So actually, I've interviewed attorneys in Florida and have another, in fact, I think last week or 2 weeks ago was an attorney in Florida. I have another one coming up in a couple of weeks. So personally, I used to live in Florida. I'd like to move to Florida. My wife doesn't. So until I can afford to pay for a divorce, he said jokingly, we're not going to Florida, but I'm getting my license there and I'm looking to build my business there. So you'll see me do more and more business. I can say on the call is Chip Carmack, who's one of my team members. He's in Palm Beach Gardens and services Palm Beach County. So if you have questions there, and Chip, maybe you might want to hook up with Donna Hodges in the chat box, exchange some information there. But yeah, our goal is to do business. And then I have a Facebook group, Probate Experts. If you want to exchange information, is another place that we can exchange information if you have some questions there. Okay. National Proprietary Attorneys to answer all my legal questions. Okay, so Barbara Owen says she has a PPLSI app that allows you to access national proprietary attorneys to answer all your legal questions, keep you informed and out of trouble. OwensBLadiesOfJustice.zoom.com. Okay, very good. So there's an app you might want to take a look at, and she has her contact information. Interesting. Haven't heard of that, but it sounds like an interesting thing worth checking out. My goal is to create, on this call, a network of attorneys across the country that we can ask these questions to and refer to and help build their business, and they can build our business as well. So that's kind of what I'm looking to do. Okay, I think I'm up to date on the chat box. Matt Price has a question. Matt, let me unmute you. There you go.
There we go. Have you found that with commercial properties going through probate has been a problem, or is it pretty seamless, or if it snaps in with the rest of like the residential real estate?
I haven't seen it. I haven't seen any big difference in speed as to when we can wrap things up from a transactional point of view. Really, except from this, if there's substantial commercial properties, there's typically more money on the table, so there might be more people fighting over things. But typically, commercial properties are in an LLC, so that might be it's out of the estate of the individual altogether. But I personally haven't seen a big time difference.
Yeah, I'll say I currently have a listing for a retail commercial property, and I have a pending on industrial, both through probate. And I can say that they really are both ends of the spectrum. They are either done properly because they're bigger property, there's more money involved, they get better realtors, better attorneys, paying attention, things are done right. Or the other end of the spectrum, there's so much money involved that people try to shortcut and cheat the system. And that's where I'm trying to catch that deal. We got a deal where they're, I think, trying to sell it on the cheap. I brought an investor in who overbid, and we got the property and make a lot of money by being there. So I would say a little bit of both. It just depends. But by and large, there's not as many as Rob said, because people more net worth tend to have estate plans, but they still do sometimes fall through the cracks. And I had a case where a client became incapacitated. He was a real estate investor with like hundreds of small lots and about 40 pieces of property, and we disposed of a lot of that. And that was a fantastic opportunity for me from a business point of view. But it was conservatorships, probate, trusts. It was the whole gamut. But to answer your question, it's the same process, the same rules apply, but because you have different money involved, you get some of both ends. Does that help a little bit? Matt, you're muted again.
It does. I've had in my case, I've had 2 or 3 that who created LLCs, and the individual who passed away was the member manager. So it was, the courts didn't know how to handle it because in our particular state, an LLC is a separate organization, a separate entity, so to speak, and they did not know exactly how to deal with the commercial part of that versus because the LLC was never in the last will and testament, or there was no mention of it anywhere. So even in the trust, so we had to basically figure out how to work around a lot of the laws that were, hardened for. This is what happens if somebody has a interest in a corporation with stocks, bonds, trades, and that kind of thing. And if they're a member manager of an LLC, we had to figure out if the authority was going to be granted to the executor of the estate to work with the LLC. So there was a lot of that took 2 years in order to walk around that legal nightmare.
There you go.
Yeah.
There you go.
And then it reminds me of another point. There are 2 things. One, as we've been saying, for all states are different. There's different laws in all 50 states. So you do want to check with somebody to make sure specifically, how it works in your state. Additionally, folks that sometimes they don't own property themselves. They their property is their business, and they own it with other people. So excuse me. You might be a trustee. You might be a personal representative in a probate. You might be a conservator, but there might be business owners. There might be members of an LLC that you have to deal with. And then operating agreement might have things that are totally opposite to what the trust says. So those are times where you have, areas not only of business law, but of estate planning coming together. You're getting very, very close to litigation. Ideally, the attorneys work together. So everything speaks to each other, or there was one attorney doing everything, but that is something to worry about as well.
And I think my main goal of this call in this series is not that we provide the answers to our clients of these questions, but that we maybe bring these questions to their attention and make sure and find out who does your LLC and your commercial work, who does your real estate estate planning, Are they conversing? Asking those questions, I think, is important. And that's also a way, as a real estate agent, I believe you can build your network of providers, because now you go from just being a realtor when they want to sell a house to helping your client, prevent getting themselves into problems. So that's the goal here. Is, again, I'm not here practicing law. I am here to learn how I can be more valuable to my customers, and in the course of that, bring business to the attorneys that they work with. Joyce, you've been patient. I see your hand up. Go ahead and unmute yourself. And how can we help you?
I was wondering if you could give us advice on the best way to work with attorneys to get them to give us referrals.
Here you go, Rob. Here's a question. How would a real estate agent in your market, Henderson, Nevada, how would they position themselves so that you would do business with them?
Responsiveness. That I cannot, I have a client who's currently doing something in a probate matter, and it took over a week for their broker to get back to them. And if I was doing probate, I would for sure not recommend that. I would for sure not recommend that broker anymore. So really, it's responsiveness, and it's we all get busy, and we all get slammed. That totally makes sense, but it's really communication. People can. I personally not a real estate agent or a broker, so I don't know how to make things sell for more, sell for less. That I was not given that gift, but I think it goes when someone's responsive. It also is a sign that a lot of things are important. That's going to make that whole transaction go a lot faster with a lot more value for people.
I'll say, Joyce, you're a real estate agent. Where do you practice?
Orange County,
And what company are you with?
Keller Williams.
Very nice. So, and I grew up in the OC, by the way, so welcome. So I will say that, when I talk to people about my company, and we all talk about commission splits and fees and money, and the thing they never talk about that probably is why I joined the company I'm with EXP, is because of the broker responsiveness. And I'm talking to our brokers once a week in our virtual world. I host a coffee with them every Friday. I think it's really important to have that relationship. So I would say to you, if you're with Keller Williams, what's the relationship like with your broker? Make sure that, or whoever answers those questions for your organization, you really need to invest in the time and that relationship when you don't need it, so that when you do need them, they're responding to you. And I think as a real estate agent, those relationships are so important. They don't go in your resume. People don't see them, but they're worth the work. And I would say whoever it is, sometimes companies have like multiple branches, and there's really the attorneys in another branch. It's worth going there. It's worth taking their classes. It's worth introducing yourself to them. So when you have a problem, you can meet them. Great question, Joyce. Thank you so much. Bob Dorfman, I see your hand up. You're next. How can we help you?
Hi, Bill. Thank you. If someone sells a home that was in a trust, what happens if the proceeds don't get put back in that trust? Is there any rule or law that you're breaking if for one reason or another they just don't go back?
It would depend on the instructions in the trust. Typically, similar to if a natural person sold a property, the money would go into their bank account, unless you gave another instruction to escrow. The money would go into the bank account of the trust, and then the trustee would do with what they're supposed to, unless they have an instruction that they can do otherwise with it.
If the owner of the trust is alive, does the trustee still have a role?
So the grantor is the trustee and is also the beneficiary at this time. One person is all three, correct?
I'm afraid I'm not understanding. So the owner of the trust and the owner of the property she's still alive, and the trustee, who is identified within the trust, do they have a role to play when that
Let me help this, Rob. Let me help a little bit with definitions here. So I think what Rob's asking, what Rob Tzall is asking you, Rob, is to identify the parties. So if the person's alive, generally, the grantor of the trust is still the trustee of the trust, if they're alive, generally speaking, as well as the beneficiary of the trust. When they pass, then there's a successor trustee who then takes over. Generally, people remain the trustee of their own trust when they're alive, unless they're, for some reason, incapacitated. So I think what you're asking is if they're alive, generally, even if they have a trust, they're still making the decisions on their trust, or if it's husband and wife, usually they both, one or the other or both, can make those decisions. When they pass is when the successor trustee takes the steering wheel, so to speak, and drives the truck. Is that close, Rob?
Thank you.
Got it.
I appreciate that. Thank you.
Yeah, I speak realtor, by the way, Rob, so just for what it's worth. It's a little different. Good. Rob Dorfman, thank you so much for your question. It was a great question. And look, for all of you, this is from beginners to experience, but we've got to learn the definitions and the procedures, and we all start somewhere. So, and I think for all of us, hearing it again and saying it again forces us to learn it better to be able to explain to people. So, great question. Okay, I don't see any other questions. We're getting up in the end of the hour. So let me do this just to kind of wrap up. Rob, I have your contact info, but just verbally, if somebody had business in Nevada or Utah or New Jersey and New York, and we're interested in estate planning and or family law questions, how would they get a hold of you?
Sure. Easiest way is to come onto my website. That's contemporarylegalsolutions.com. And you can fill out our contact page and we'll get in touch with you. We'll get in touch with you within 24 hours. Or you can email me. It's my personal address is robert@contemporarylegalsolutions.com.
Fantastic. And I'll put that in his in the chat box. So we'll have that in our show notes on the various social channels as well. And then, of course, if you need him, feel free to reach out to me. Be glad to reach out and catch him. And if I can't get a hold of him, I'll call his wife and she'll flag him down because she keeps him on a short leash. So, Rob, on behalf of everybody, thank you so much for making time today. I know, like you, this is our Passover holiday and you're getting ready to spend time with your family. We schedule it here, I think, but I really appreciate making the time to educate people. And I think important to not just tell what the law is, but how to work with somebody like you who's a professional to bring some business and to earn that trust. So thank you so much for being on today.
I appreciate it. Thank you so much. Everyone have a great day.
Chag Sameach. And for the rest of you, I want to say that we do this every week. I'm Bill Gross, the LA Probate expert. We do this Probate Weekly call every Thursday at 4 o'clock Pacific time, 7 Eastern time. It's recorded live. It's on YouTube and Facebook and LinkedIn. We stream it live as well as put the recordings on there. If you have questions, if I can help